And we're doing this as a hybrid hearing, and it's also being broadcast on our Judiciary of Guam YouTube channel. Will the clerk please call the case?
This is Supreme Court case number CVA 22-015, Angel Miguel Diaz Cruz, plaintiff appellant, v. Joseph M.M. Cruz, defendant appellee. Appearing for plaintiff appellant is attorney Braddock Huseman. Appearing for defendant appellee is attorney Curtis Vandeveld. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, Associate Justice Catherine Merriman. Attorney Huseman reserves 10 minutes.
Mr. Huseman, you may proceed.
Morning, Your Honors. Mr. Chief Justice, may it please the court. This case is about constructive notice and whether the Guam's Registry Act can be used to launder a fraudfeasor's fraud. The appellant in this case, Mr. Cruz, is elderly, and is so often the case in our community with our elderly members. They are reliant on their family members, their children, for a certain amount of care to assist them with their lives. One of Mr. Cruz's children, his son, Joe, abused that trust and stole 2 pieces of property from him. Joe then, with those ill-gotten deeds, ran down to the registrar's office, recorded those deeds. And later, when Mr. Cruz found out that he had been defrauded, he brought suit. Mr. Cruz's son's defense to that was to point to the time that he recorded the deeds and say that, well, he knew or should have known, my father knew or should have known that I stole that land on the day I recorded those deeds because of the public notice the registrar's office provides. The trial court accepted that as a defense, dismissed the case for want of jurisdiction, and we're here today. The trial court erred in 2 ways. One, I would say it's legal. One is a policy choice. The legal error is that the trial court ignored the statute and expanded its definition. By its terms, it applies to prospective purchasers and mortgagors. And then the other is a policy issue. The trial court used the Public Records Act or the public records to be a complete defense to fraud. And that was error as well. And I'd like to discuss both of those errors today, but first I'd like to discuss the legal error.
Before you do that, can you
Sure.
just briefly address the jurisdiction issue that was raised by Mr. Vanderbilt?
Happy to, Your Honor. In this case, we believe this court has jurisdiction on an appellate level. The case was dismissed. It does not say with prejudice. I don't think that's required. There was nothing else for my client to plead. In this case, the court used the date that the deeds were recorded as the inquiry notice date. No one disputes that 3 years have passed. To plead a negative in that case is nearly impossible, as we've pointed out in our briefs. If the trial court is going to use not an inquiry date, not a discovery date, not when the plaintiff discovers the fraud, but when the fraud feaser registers the fraud, it's very difficult to plead the negative. And I would say, even in this case, they did plead the negative, but the court didn't accept it, which is to say that he's frail and is dependent on his children. So there aren't any facts that he can plead to get around this fact, if that's the date you're going to use.
And notice of the decision was entered on the docket, right? The separate document rule was satisfied.
I believe it is. The judgment is so ordered, and additionally under this court's, and we point this out in our briefing, under this court's 150-day rule, even if it wasn't satisfied, it's satisfied by the time lapse. So there's nothing else to do. There's nothing else that could be pled. He would have needed permission from the court. Mr. Cruz would have needed permission from the court to replead. This was a first amended complaint that was dismissed. It wasn't granted or it wasn't given. The court clearly thought it was disposing of the issue, and I think the intent there is to dispose of the issue. So this court has jurisdiction.
Okay, you can proceed to the legal argument.
Turning first to the legal reason the trial court erred. the court conflated constructive notice that is provided by the Public Records Registry with inquiry notice of fraud. 21 GCA 37101 is the recording statute here, and it is very specific, and it applies, the plain language applies to specific groups, in this case, mortgagors and prospective buyers. We could use another term for those: investors, people who are going to do due diligence and put their money into a property. It does not mention people who have already purchased property. The trial court, however, assumed that the statute also applies to people who currently own property. And Mr. Cruz as an owner falls outside of that group of that class that's in the statute. Under Guam law, and this is where the courts conflated the terms. Under Guam law, fraud is accrues when the plaintiff, using a reasonable person standard, discovers the fraud. The trial court flips that on its head by using the statute, and now it isn't the reasonable person discovering the fraud. It's, well, the public has general notice because of these public records, and it allows fraud feasors to, like I say, launder the fraud through the public record system. It would be one thing if the statute included a certain class of people like homeowners and required homeowners to constantly check the public records to make sure that their property is safe, but it doesn't do that. And so it's unreasonable to require homeowners to do that when the statute doesn't require it. It's conflating those terms.
The trial court seemed to rely on Title I. It did, where we had concluded that the statute of limitations for a fraud claim had run in that particular instance. What makes this different than the Title I case?
Well, I think I'd have to go back and look at the Title I case. What I think is incorrect here, and I don't think Title I covers, is the discovery of the fraud isn't tied here to the plaintiff. It's nebulous and tied outside the plaintiff. Now, it might be that, as an example, there could be situations where there are documents that indicate, there are public records that indicate, right, that the plaintiff should have been on notice. So you could imagine a situation where it's a deed, but the deed says, there's something within the deed that says, I'm giving this land to you because of my affection, because of how well you've done as a son, and spells that out. And then there might be contemporaneous things along those lines.
Like if tax bills were not being sent and he didn't receive them or didn't pay them.
Correct, Your Honor.
The son told him, I'm paying the tax bills.
Right. There are ways that notice could be here, but here we're at a 12B stage. There are no pleadings, and what the trial court did is, instead of using Mr. Cruz's discovery, it used a statute to impute discovery, even though the statute doesn't cover it. And that's why we think it falls outside of Title and outside of really all the case law in California, where our recording statute comes from, and even cases from Hawaii that we've pointed out. And that's why we think that the trial court made a legal error when it made its rulings. There's also a public policy problem with the court's ruling, and it puts landowners and homeowners in a position of prophylactically having to go check periodically, not just once, but perhaps every month, but a certain amount of time you have to keep going to check to make sure that your property hasn't been stolen. That is not the purpose of the recorder statute. It's not the purpose of the Recorders Act.
2 years, 11 months.
2 years, 11 months. Yeah, every 2 years and 11 months, you have to mark on your calendar, run down to the recorder's office and see if anyone's done something with your property. That's not the point of that statute. It turns the statute on its head. The statute is designed to allow, as I said, investors to do their due diligence. It's designed to facilitate transfers, legitimate transfers of property. It is not designed to launder fraud. And the way the court used it here is to launder alleged fraud. Now, we are at the 12B stage. Facts that are taken as true. And what Mr. Cruz is asking for is just the ability to get to discovery. The trial court found that he pled fraud, just found that it lacked jurisdiction. And for those reasons, we're asking this court to reverse the trial court's decision, send this back, and allow Mr. Cruz to proceed with discovery. And I know I've kept it short, but if there's no other questions, I'll reserve the remainder of my time.
I don't have any questions. All right, thank you, Mr. Huseman.
Thank you, Your Honors.
Mr. Vanderbilt.
Thank you. If it please the court, Your Honors, Mr. Chief Justice, at the outset, I want to thank the bench and Mr. Huseman for the accommodations relative to scheduling this matter. The progress of this appeal has been somewhat delayed because of my open heart surgery. I really, really appreciate sincerely the accommodation everyone has shown to me. So thank you. So
Let's talk about jurisdiction first. I mean,
Sure.
Is it your position that anytime a trial court enters an order granting a motion for dismissal for failure to state a claim that it is required to put with prejudice?
no, I cited to the Scott versus Eversole mortuary case, and in that case, the Ninth Circuit Court of Appeals in dealing with when does it constitute a final order said that an order dismissing a complaint but not dismissing the action is not final and appealable under 28 USC section 1291, which is very similar in language to our statute.
Well, we have case law, the Portis case, that says ordinarily when an order or judgment granting a motion to dismiss for failure to state a claim amounts to a final judgment.
And in this particular case, I don't think it applies because of the fact that there was earlier grant of request for leave to amend when it was made in the first motion to dismiss. And there still is the ability to go back to the trial court and ask for leave to amend. But
How would he be able to amend his complaint to defeat the statute of limitations determination that the court found? I mean, what's left to amend in that instance? I mean, it seems that the court has said, based on the facts and the application of this statute, there's no further, basis for the claim to go forward.
actually, I'm not in agreement with that. I understand the argument by plaintiff appellant, but the problem is that
So how could he have amended the complaint to survive?
he could have made a motion for reconsideration and asked the court below to give him leave to amend, which he did not ask.
But how would he amend the complaint and
Well,
survive the statute of limitations finding that the court made?
he would meet the requirements of what the court had said in the first motion to dismiss and what the court has said, which is he did not plead when he discovered. It's different to.
No, he did in the second amended.
No, he
complaint.
didn't, Your Honor, and I'll explain why. What he said was that he knew he had a basis to sue when he met with his lawyer. But that is not consistent with this court's holding in Custodio versus Bumpcom, which is this court has consistently said it's when you are put on notice, when you have some reason to suspect that you have been harmed, that is when the statute of limitations begins to run. That was clearly spelled out to the plaintiff at the time of the first motion to dismiss and leave to amend. So
Paragraph
in
12 of the first amended complaint says plaintiff discovered upon presentation of the herein described documents with advice on or about November 29th, 2019. Isn't that an allegation of when he discovered it?
No, that's an allegation of when it is that he conclusively determined it to be the case. if that were the case, then all of
It
these
says he
medical
discovered it.
malpractice.
It says it discovered it at that time. And isn't the pleading supposed to be taken in the light most favorable to the pleader?
Pleadings
Yeah.
are to be construed in a light most favorable, but I don't think that that means that you can extract and compartmentalize a particular word and ignore the remaining words of the sentence. As this court has said, words are known with the company they keep. And that being the case, you can't ignore the remaining words of the sentence.
So what is
And-
the remaining words of the sentence that you suggest don't provide the dates sufficient for the court? I mean, I thought the court itself in its decision said he had pled the fraud with particularity and accepted the date of the discovery to be November, but based on that date and the 3-year statute of limitations, it didn't apply.
I don't think that is what the trial court said. And again, I go to the cases that this court has had regarding when the statute of limitations commences to run. And what he says in paragraph 12 is plaintiff discovered upon, it's a misspelling of.
But the court specifically cites paragraph 12 on page 7 of its decision. And it says the first instance, I mean, it says it discovered it on November 29th, but then the court goes on to say they should have known about it on March 2014 when the deed was recorded. So
No,
it's relying on the March 2014. I mean, if you look at page 7 and 8. of
I
the
believe that's a
decision.
misreading of the trial court's decision. The trial court says that that would be the date that you would start counting the statute of limitations. It doesn't say that that's the date of discovery. It says that would be the date you would start. And unless there are facts that are pled as required in the Amsden case that show that that date should be some date later than the date of the recording, then it should be that until that's done, you can't claim that you are within the statute of limitations.
Well, I'm looking specifically at the trial court's language. I don't want to quibble with you, but it says the first incident in which plaintiff could have discovered the wrongful act was on March 24th when the defendant accorded. This would have put plaintiff on constructive notice of those deeds. It was at that moment on March 2014 when the statute of limitations began. And so it didn't have any reference to the discovery.
It said that that is the date that it could have, that the plaintiff could have. And so the court has no other date to be able to go upon. And citing to paragraph 12, the court said, this is not the date of discovery. The date of discovery, the court rejected that as being the date of discovery. The date of the 29th of November was the date that he met with his representation and advice of counsel. If that were the case, then anybody who has a claim, such as a medical malpractice claim, as in the Boom Procon case, they would be able to say, yeah, I know that was 7 years ago, but I didn't really know that I had a claim until I met with my lawyer and his physician who assists him, and they told me it was malpractice.
All right, let's go back to the actual, on the concluding language. The court says that the statute of limitations expired on March 14, 2017, 3 years from the date the plaintiff was on constructive notice of the deed and should have suspected his wrongdoing. So the court clearly is using the March 14, 2017 date. So if the defendant is pleading November 2019, that's going to be outside that. And the court recognizes that by says the court lacks jurisdiction because the statute of limitations has expired. So are you suggesting that he would go in and amend his complaint and somehow allege that I don't see how with those dates established by the court, right? The court established those 3 years, March 14, 2014 to March 14, 2017. So that is the applicable period of the statute of limitations as determined by the court.
That was,
And we're only talking about this for purposes of jurisdiction here right now. We're not even talking about the merits, because you're suggesting that the court's dismissal of the complaint and not putting prejudice suggests that he can go back and amend his complaint. And my question to you is, how do you propose he amends his complaint with those parameters established by the court and the date that he discovered, where it would somehow survive and not be a final judgment?
and I indicate that I believe the court started the running of the time from March 24, 2014.
There's no doubt.
Okay,
And it
I'm
found the
saying-
end of the time to be March 14, 2017.
I'm saying I believe that the court accepted that as the date, because that would have been a date in which events occurred that could have first put him on notice.
Right.
He did not plead. He did not plead that he didn't know. He never said anywhere in his complaint that he didn't know. What he did say at paragraph 12 was he became aware he had a cause of action when he met with his lawyer on November 29 of 2019.
That's not what paragraph 12 says. I just read it to you, but you can say what you feel it is. I mean, paragraph 12 says that
It says
he discovered it.
plaintiff discovered upon, and there's a extra O, I believe it says presentation of the herein described documents with advice on or about November 29, 2019. That's saying that's the date that he met with the lawyer and he had advice as to whether or not he had a claim. That is not the date of first discovery. There is nothing alleged in paragraph 12 of the date of his first
But
discovery.
Mr. Vanderbilt, why do you,
Yes, Your
why do you even care? Because the date that he's saying that he first discovered goes beyond the time period that the court specified is within 3 years, which is in your client's favor. So why do you care what he pleads if it's outside that time period? That's his admission. Why quibble with that? It's in your client's favor.
The only thing that I'm trying to do is make sure that what is being discussed accurately. And I'm saying that I believe that relative to the public policy argument, I believe that the application of this statute is not limited to just the circumstances of a prospective buyer and them being on notice of what is on record. I believe.
But isn't that the specific language of the statute? It's 21 GCA 37101, which the court relied upon, says that every conveyance of real property is constructive notice to subsequent purchasers and mortgagees.
Yes.
Clearly,
I think that you can equally apply that beyond that to the seller or to the holder of title. There's nothing in the statute which says otherwise, but that's what I believe is appropriate.
so you think it should apply to anybody once it's recorded?
Believe that.
How do we deal with this issue if someone just records a wild deed, has been suggested, goes in, records a deed fraudulently, and no one goes to look at it? You're relying on this statute to say in every situation after 3 years expires, it's too late. You can't do anything about it, no matter when you discovered the fraud. Is that your position?
Real property, fraudulent real property transfers occur with greater frequency throughout the jurisdictions of the United States, and it happens without there necessarily being what you refer to as a wild deed, which is something that wasn't actually made by the then owner of record. But I believe that a person has a duty to protect their interests in their property, and I think that
And so
they are on
automatically,
constructive notice. I believe that they are on constructive notice of what the state of their title is with the recording entity. And as you brought up, that's usually something that they are aware of because they receive their biannual, their semi-annual property tax statements. Nothing in here that Mr. Cruz received his semi-annual property tax statements, nothing alleged in the complaint to show that, to say that he wasn't aware that he was somehow relieved. All of those facts
those
not
are
in the record.
factual, but those are factual, with that, this is a 12B6.
Yes.
And those are factual disputes potentially that could go towards the notice. But right now, in terms of the allegations and the trial court's determination, it relied on this 37-101 provision, which by its express terms only goes to purchasers and mortgagees, but you say it's a broader category of people that should be covered by that. So with that 3-year statute of limitations.
And I'm not saying it relative just to the statute. I'm talking about the concept of constructive notice overall.
Right, but
Okay.
but that seems to be a factual issue. And if there's a factual dispute about when constructive notice was provided, but here the trial court didn't acknowledge there was any factual dispute. It said the date of constructive notice, at least in its determination, was or when he alleges was the 19th, but there's a 3-year statute of limitations by virtue of the recording statute for 3 years. So he's out of luck.
Because the court was applying the standard of Amsden versus Yaman, which places the onus of pleading alternative facts other than what would be something which showed the first possible opportunity for the person to have notice, and that he would plead the facts that would show that shouldn't be the date applicable, which he did not do. And citing to the fact that it's the day that he met with his lawyer and his lawyer told him he has a cause of action is not.
But what if that was the date?
First become
What if
aware.
that was the date?
Well, then it should be pled that way. That's his responsibility.
But it seems like he made a genuine effort to plead that he discovered this on that date.
I don't agree. I think that if you look at the original paragraph 12 as it was, and what the arguments were that led to that order that granted leave to amend to make the change was only to insert a date which was within 3 years of the date of the filing of the complaint, and was based upon not when it is that the plaintiff first learned that he might have been harmed, but was a date he was convinced by counsel that he had a claim. That's not the standard for the starting of the running of the statute of limitations. The starting of the running of the statute of limitations is based upon when is a person first alert to facts that would put him on notice that he may have suffered harm.
But that's not what the trial court found. The trial court found that the running of the statute of limitations starts when the deed is recorded. That's basically what the trial court found by relying on 37-101.
With no alternative facts pled as to when it is he first became aware. And I think that that's a significant distinction. The trial court looked at this matter and said, in the absence of pleading sufficient facts under the Amsden versus Yaman holding, I'm going to look at when it was you first could have been put on notice, and that was at the time of the recording of the deeds. And I have no problem.
I think the trial court very clearly in my mind found a 3-year statute of limitations and said he failed to provide any reason why he failed to file the complaint within the 3-year statute of limitations. And that's why it dismissed
which he didn't do.
Yeah.
Show me in the decision where it is that he alleges that in that 3-year period of time, he did not learn that there was a cause of action.
I don't think he has to allege
I
when
think
he
that's-
did not learn. I think he has to allege when he learned. And I think he did that.
No, he alleged when he was convinced
Yeah.
he had a cause of action. And I think that's where we fundamentally
Yeah,
disagree.
I think we do.
Yes, I think we fundamentally disagree that it is the date he is convinced by a lawyer. And if that's the case, all of the cases that stand upon when it is that a person is first on notice or has the opportunity to know that they have a cause of action, that case law will all change. All of the statute of limitations case law that this court has developed will be modified by this, and it will be based upon all you have to do to get your claim before the court is say, I didn't know I had a claim until a date within the period of the statute of limitations. That hasn't been the holding of this court. And you have the power to do whatever it is you believe to be the best interest of the law. But I think it's.
So let me try and explore that last statement that you just made.
Yes.
And so you're asking us to follow your interpretation of the statute, that the mere filing of the deed provides constructive notice of the recording to everyone in the world. And so when was the last time you, Mr. Vanderbilt, researched your grantor grantee index on your home?
I think that the last time I did that would have been probably in the last 2 years.
So what triggered you
been,
to do that?
Yeah, I was going to say it would have been because of the fact that I was contemplating getting a appraisal of my house. My health condition was poor. I wasn't sure whether I was going to continue to practice. And so I made that determination. But I also advise.
Let me just take a step at a time. So,
Sure.
So there was a reason why you researched your grantor grantee index, because
Yes.
you were going to take certain steps that affected the property.
Yes.
In this particular case, why would the Regis, right? The elderly, the parent.
Yeah, Mr. Cruz.
I'm sorry, Mr.
Miguel.
Cruz. Yeah,
Yeah.
Mr. Cruz. What was the duty that he had that would lead him to suspect that his son was defrauding him?
It was brought up earlier, which is, as to my house, I get the real property tax statements every year. So that is the one thing that assures me that the title is still in my name, because if it wasn't, the records at Rev and Tax would be changed to reflect the transfer of title. And you can't just record a wild deed without the affidavit of true consideration. And so that synopsis just kind of ignores things.
Your experience with Rev and Tax, that their records are accurate to the moment that the deeds, that the taxes are issued, and that you can totally rely on the Rev and Tax tax statement as to who owns the property?
I wouldn't say that their records are 100% accurate, but I believe that they are largely accurate. And I further believe that that if Mr. Cruz alleged in his complaint that he was still getting real property tax statements up until November 29 of the year before he filed the complaint and met with his attorney, that might be facts that would meet the standard under Amsden versus Yaman, that would put the court, give the court a reason to say, okay, so you couldn't have been on notice until this date.
But let's not expect, let's just deal with what the facts are in this 12B6 motion,
Sure.
as the Chief Justice has stated. And in this case, the trial court said that March 14, 2014, the quitclaim deeds were recorded, was the triggering date that provided notice to the world in reference to the recording of the deed.
Yes, Your Honor.
The statute says that if someone is going to purchase this property, or a bank is going to provide a mortgage, that it was duty bound, because there's a reason. When you're a purchaser and you're going to purchase a property, you want to make sure it's free and clear of any liens and say it's a mortgagee. But to a existing owner of the property, like yourself, in reference to your house, who there is absolute no reason to go and check the grantor grantee index. For us to follow your interpretation will require everyone on this island to go down to Department of Land Management every 2 years and 11 months, maybe even more often, without any reason whatsoever to suspect that anything has been done to affect the deed. Is that really a reasonable interpretation?
I don't think that that is the interpretation that I'm saying. I believe that if he had said, I wasn't receiving the real property tax notices, that would be something that would have altered and possibly shifted. But it also could be that that puts him on notice that there is a
But
change.
as I stated at the outset, why do you care? He pled a date that he had knowledge that was 5 years later than when the deed was recorded. If we followed your interpretation, you've won the case. So why do you care when he found out, when it's beyond the 3 years, as to what the trial court stated was the date that triggered the constructive notice to all of the recording of the deed?
I'm addressing the arguments that have been put forward by the opposing party. And that is why it is that I am addressing the matters. I do believe that the recording of the deeds put Mr. Cruz, the elder Mr. Cruz, Miguel Cruz, plaintiff appellant, on notice that there had been a transfer of title. He did not get any notices about the real property taxes.
Well, there's nothing in the
There's
record
nothing-
on that.
But you see,
Vanderbilt.
we go back to who had the affirmative obligation to plead. And under Amston versus Yaman, that affirmative obligation rests with the plaintiff. And plaintiff did not plead anything other than the date that he claims he conclusively knew. And that's not the law on the running of the statute of
But
limitations.
Mr. Vanderbilt, why don't you
Yeah.
just stipulate? Okay, I'll stipulate to what Mr. Huseman has pled and submit on that, because when you do that, you've won based on the trial court's interpretation. But no,
Mr.
you're
Huseman's
arguing.
argument is that all of that time between the 2014 and 2019 is told. Because
No,
of the,
he doesn't argue that. He argues that when he was first learned about it was 2019, and the trial court said, yes, you did learn it in 2019, and the 3-year statute of limitations expired in 2017. So therefore your complaint is dismissed. There's no argument about any tolling.
yeah, I believe that that the trial court was applying when it was that he could have first known. And that is, I guess, where you read the opinion differently than me. But I find.
I mean, the
that
trial court says that he hasn't justified why he failed to file his complaint within the 3-year statute of limitations.
Right.
So
that's saying that is in essence saying you haven't shown why you didn't learn.
No, he's saying you have to file it within 3 years. And if you don't do that, you lose. And so the rule that the trial court came up with is exactly as you said. When they recorded the deed is when he had constructive notice. And that's the rule you're asking us to adopt. And what the trial court adopted.
I'm asking you to adopt that to be applicable in the event that the pleading party does not meet the duty and obligation under Amsden versus Yaman, which is the obligation to plead facts of when it is that the person first comes upon notice. Not when
you're saying he has to plead that within the 3-year statute of limitations, which it already had expired.
Or show why it is that it should be told.
But
we have
he's not arguing for a tolling. He's not arguing for a tolling of the
But there-
statute.
Well, he hasn't cited, he has not cited the tolling statutes in his brief. But that would be law applicable to his position if he were to say that it was a date other than.
It would only be applicable if the 3-year statute of limitations applied. If the 3-year statute of limitations did not apply, and he alleges that he had constructive notice in 2019, why does he need tolling?
Because the statute of limitations under the case law that this court has developed commences to run once a person is aware of facts.
Right, so let's
Should put him on notice.
hypothetically, let's say his pleading says, I discovered this in 2019. Forget about lawyer giving him advice, or just say, I discovered this in 2019. That's what he alleges. And so,
I can't parse the words out in the same manner that you just did and ignore the rest. I think
no,
that-
but this is a hypothetical,
I
Mr.
understand it's
I'm
hypothetical.
trying to understand the rule that you're asking the court to adopt. And so hypothetically, a plaintiff comes in and says, I discovered this deed in 2019. The deed was recorded in 2014. And the trial court said, well, the date that the deed is recorded gives constructive notice. And therefore, it expires in 2017. You said you discovered the deed in 2019.
So
Under those facts,
So I think
what
we're-
happens?
So I think where we are at the point of inquiry is, what is really the burden under Amherst?
No, I'm
versus
not
Vermont?
asking about burdens. I'm saying this is the fact. I'm
And
picking
I'm-
apart
and I'm-
his failure to plead, as you say. I just want to know the rule of law that we're trying to look at
And
here.
I believe that the rule of law is that you look at when is the first possible time the individual could have known.
And he
that
said
would-
it's
that-
2019,
No.
under my
that's-
hypothetical. He says
no,
it's
he says that's
2019.
when he knew.
No, Mr., it's
Okay.
not I'm asking a hypothetical.
Okay.
I'm getting away from your
Okay.
reading of paragraph 12. I'm saying a hypothetical. He discovers it in 2019. The deed is recorded in 2014. 3 years later is 2017. So I'm asking you, he says the first time I discovered it is 2019. Not, I got advice from lawyer, none of that. I discovered it then. So he's out of luck.
And I am responding based upon those hypothetical facts.
Right.
The hypothetical facts that you gave are,
Right.
one, the recording of the deed in 2014, which is the first opportunity for a diligent person to know that they have a
Okay.
claim.
Okay,
So I am responding directly to your inquiry on
Okay.
hypothetical facts. And I am saying that that should be the date for the initial application of any statute of limitations until the person meets the burden under Amsden versus Yaman and says, I could not have learned on that date. I didn't learn. I was first put on notice of
Okay.
possibility of harm on this particular day.
so
by these
2019.
particular circumstances.
So in my hypothetical, he didn't learn until 2019.
In
So,
your hypothetical, you say that that's what he says,
right,
but I don't think that that is a sufficient pleading of facts and circumstances of when it was that he first would have been put on
he said,
knowledge.
I first knew in 2019. That's what he
That-
said.
That I don't think is sufficient.
So
I don't think that pleads sufficient facts, and I guess that's where we
what
keep
would,
coming
what
back to
would you
disagree.
require him to plead?
He would have to plead how it was he came to know the circumstances, and that date is applicable.
That was the
which he
first
doesn't
date,
do-
that
which
was
he
the
doesn't
first date
do.
I found out that the deed was
right.
recorded. Was 2019, the first date I found out. So now he knows,
I-
so,
I don't think those are facts and circumstances that show when it was he was first able to understand.
I don't
I
understand that.
understand what you're saying.
Yeah.
What you're saying, Your Honor, is he's saying that's the date he first knew. But that's not what starts the running of the statute of limitations.
That's
And
what I
this is
just
where
want-
we are at loggerheads.
No,
And I'm
that's,
saying to you, it would be the date that facts and circumstances would have put him on notice.
which
You
is
know,
the date of the
if I-
recording of the deed. So that, I just want to understand that. That's your position.
That is my position.
Okay, that's all.
Otherwise, you wait until a guy's toes fall off in a medical malpractice, and he says, well, gosh, I didn't really know it was that bad until the toes fell off. I just kind of thought it was, aging and stuff. I did notice, 2 months after the doctor treated me that they were turning purple, blah, blah, blah. But I just kept waiting and waiting.
I understand. I just want to know what rule you're espousing, and your rule is the recording of the deed in March 2014 starts the statute of limitations, exactly what the trial court found. And after 3 years,
Unless the person meets the affirmative pleading obligation under Amsden versus Yaman and pleads that there were no circumstances that would have triggered his knowledge until a certain time. Not when it is I meet with a lawyer and the lawyer tells me I have a cause of action.
I understand your
Yeah.
position.
Okay. Because otherwise you're holding in Bupropion would go out the door. All your medical malpractice determinations on the running of statute of limitations would be equally as fleeting, because it would be when the person decides that they have a claim and they meet with their lawyer, and not when there are events that put them on notice that there's potential injury.
Okay.
I
Thank you,
know
Mr.
that I've
Maxwell.
exceeded my time. So again, thank you very much.
Thank you.
No, I don't want to excite Mr. Vanderbilt anymore.
Mr. Hughesman? Can you address the argument that he makes of the affirmative duty to plead, why you did not have knowledge when the deed was recorded?
Sure, Your Honor.
And your failure to do that allows the trial court to grant the dismissal.
Well, one, with respect, I think it's a bit of circular reasoning, because if you can't use the recording date, there isn't an allegation of when the statute started to run, save for my client's allegation that this is when I learned about it, November 2019, whatever the allegation in paragraph 12 is. So I think there's a difference here between notice pleading, which is what we require in Guam, and a plausible claim, which is what the federal government requires. And that's, I'm not saying that's what he's arguing, but I am saying that this seems akin to that, which is ever more facts to plead in and make the claim quote unquote plausible. So if the statute doesn't begin to run the date someone uses the recording system to launder their fraud, then this isn't even an academic question, because the only allegation of knowledge here is the date he learned in 2019. And so to even get to this discussion, the court has to reject California case law, which is exactly where that applies, that refuses to use the Recording Act in the way Mr. Vanderbilt is asking the court to use it. And our statute comes exactly from California's law, so we would be rejecting California's law for no reason in this case. I'm not aware of any case law. Certainly we didn't provide anything to the court, but I don't remember reading any case law in Mr. Vanderbilt's brief for containing any state that uses their Recorder Act in a similar way, which is to put current owners on notice of fraud. And so if we're not putting current owners of notice on fraud, as soon as the fraudfeasor files the deed, then it's just a pleading matter of when they say they noticed, and that's in this case. Now, discovery might turn up the different facts, and I understand Mr. Vanderbilt wants to argue facts, but we're in a 12b6, and this is not the appropriate place to argue those facts. And so we're just stuck with what was pled. And what was pled, I think, and I agree with you, Justice Torres, that trial counsel did plead that this is when My client learned of the transfer, and we filed shortly after. And without using the recording statute in an improper way, there's no date of when the trial. There's no date in the record to indicate when the statute should have run. And again, the statute runs for fraud when a reasonable person knows or should have known about the injury. And in this case, I believe it is inherently unreasonable to use a statute not designed to protect them, but designed to protect the public and designed to protect investors, people who are going to borrow, people who are going to borrow, but mostly people who are going to lend, and people who are going to purchase property. That's the statute's supposed to protect investors. And instead we're going to turn that on our head. And every time there's a transaction, the fraud begins to run immediately. I don't think this has major implications for any of the other, for any case law. I don't believe this has major implications for any of the court's current case law or anything else. This is, like, as I said, this is the standard in California, it's the standard in Hawaii, and I think it's the standard almost every jurisdiction that I've looked at. And again, I haven't heard anything different from Mr. Vanderveld. If there are no other questions, I don't want to belabor the point. We are asking the.
I have no questions. Justice Merriman, do you have any questions for counsel? No questions from Justice Merriman. All right, the court will take the matter under advisement. Will issue a written opinion and will now stand adjourned. Thank you.
Thank you, Your Honors.
All rise.